Good evening, everybody. Welcome to Case by Case. Sorry about the link change. We had a little bit of technical issue. Okay, gonna fix that echo. I always seem to have technical difficulties, and I don't know why. I'm always over prepared until the last minute, and then something happens. So, welcome to the channel. My name's Amy. Tonight, I have joining me Cherie and Travis Williams. We're going to be discussing Ashley Garth's post-conviction relief appeal brief. And I'm going to bring Travis and Cherie on. They're both the link will bind. So they're going to be able to break this down. This brief is 41 pages minus the index. So I will skip through the index and we will go through section by section and give you guys the breakdown of what this means, what this entails, and what we're hoping for the end result to be. So welcome, Cherie. Welcome, Travis.
Hello.
Hi there.
Welcome in everybody in chat. It's kind of a late evening. We're getting a late start, so welcome in. I don't want to go through one by one. You guys all know that you are appreciated, and we're going to get right to what we're here to do. And we're going to start with Travis. Travis is going to tell us what this brief that we're going to go through is all about and why it's important. Go ahead, Travis.
Oh, okay. Thanks. This brief's important because it's the next step in the post-conviction review that Ashley's in the middle of. So she filed a petition for post-conviction relief and got a contested evidentiary hearing, was allowed to call the witnesses. And so we're very fortunate because you and Cherie actually attended that hearing. So, I mean, we've got, a much better picture of what happened in the hearing. And then both sides submitted their briefs and arguments before the trial court had the evidentiary hearing. And unfortunately, denied Ashley's post-conviction petition. Then her attorney immediately filed a notice of appeal. Then it takes a little while to get the clerk's record prepared and then the transcripts, but those all ultimately got prepared. And then her brief was due and got filed timely. And this is asking the Indiana Court of Appeals to review what the trial court judge did and to find that she did make out a good case and deserves a new trial. So that's in essence what this initial brief is asking the court to do.
You're muted.
I am muted. Sorry about that, guys. Cherie and I did attend the hearing, and Ashley's public defender, John Pinot, showed up, really locked and loaded, and put on a good case. The judge overseeing the hearing was the initial trial judge who overheard the case. It wasn't surprising to us that he didn't rule in Ashley's favor, but we feel that Ashley has a great case of in her appeal. So that's why we're still trucking forward. And there's a lot of things that when you are dealing with these kinds of cases, and Travis or Cherie, both of you, you guys can just stop me in my tracks if I say something wrong. But when you're dealing with an appeal, you're limited to the facts of the case that were presented within the four corners of a document, four corners of a trial. And when you look at the case under an umbrella and there's all of these other things, for example, all of the things that we've been covering on this channel about Ashley's case, not all of it was presented at trial, which means not all of it can be discussed or presented in these appeals. And those are the pieces of the fine-tooth comb that we're trying to pick through to be able to get these things squeezed in to get her a new trial. Because if she gets a new trial, I'm very confident, and I think we all are, who know the details of this case, that Ashley has a very good chance of overturning her conviction because she is innocent. She did not commit murder. She didn't conspire to commit murder. So going forward, I just want you guys all to know, if you say, well, hey, what about this? Hey, what about that? We've talked about this. Yes, I'm talking in a broad scheme of things when I discuss Ashley's case on the channel. But when it comes down to black and white in the four corners of the document, we're limited. That's why it's very important that when you have a case like this, especially a murder or a level 1 felony case, that your attorney goes from A to Z and they bring in as much evidence as they possibly can, because it matters on the back end. If you are found guilty, you don't want any cards left off the table. And I have to give it to John Pinto, Ashley's current attorney. In this brief, this appeal that he filed, I felt like he put every card on the table that he possibly could. That's my opinion. Travis, sure.
All I will say is that it was I was very excited at how well done it was. So,
Yeah, I agree. I think so. I think it's it's a very well done brief, and the way these things go is that the state will have a opportunity to respond. There's always two sides to every story. I think there's a couple of parts in here when we get to them that I think John wrote that he's kind of anticipating a certain response from the state, perhaps. And so that may be why he crafted it in the way he did for strategic purposes. But the state gets to file their response, and then he gets to file a reply. Um,
Hey, Travis, do you see the question on the screen? So the question is, so new evidence isn't allowed at this stage. Can you answer that?
yeah, yeah, new evidence is not allowed in the appeal. New evidence was allowed as the subject of the evidentiary hearing. That was one of the things that they claimed, and we'll actually go through on the issues in the brief, that that's one of the things that Ashley and her attorneys are fighting for, is saying that they did bring up a valid issue of new evidence that justifies a new trial. But so that is appropriate for a post-conviction motion. Indiana has 9 factors, and we'll be going through those. But at the appellate stage, no, you can't bring up anything new. You're stuck with the original trial record plus what you were able to bring in during the evidentiary hearing. So you're correct on that. You are stuck with the record from the trial and then the record that's established for the post-conviction motion. Um, I hope that answered that.
I think it did. It's a complicated process, and there's a lot of things in every case that the ins and the outs, the little things that you think would matter don't necessarily, matter in the court of law. That's why it's very important that when you go to trial, that as a defendant, and I can say this for Ashley. Ashley wholeheartedly trusted her attorney, thinking that her attorney was going to do everything. So she kind of sat back, and at the end of the day, she was like, "Oh my gosh, I didn't know that she didn't know this. I didn't know that she didn't know that." And that's why, if you are ever in a situation where you are being charged with a crime, you might not be a lawyer, but you need to be a participant in your own defense. So we can go to the brief. The brief is, I believe it is, let me see here, 41 or 43 pages. We are going to read through it. And what I thought we would do is we would take section by section, and I'll read a section, and then Cherie, you can read a section. Travis, if you want to read a section, you can, or you can do, you can explain, comment, you can commentate, and dissect each section as we go. Does that sound good?
Perfect. So I think we can start going past the table of contents and I mean the first page. What's significant is what court's it in. It's Court of Appeals of Indiana, and so there's another court above that, the Indiana Supreme Court. But so that's the court, and then the first section is on page 6, statement of the issues, and the statement of the issues really is one of the most important things in the brief, because whoever frames the issues is going to win the case. And so when you see ultimately the opinion of the court and how they say what the issues are, what are the questions that are being raised, if they adopt your version of the issue, that's a very good sign that you're going to come out with a favorable ruling. And what was really brilliant about this brief is in post-conviction, there's basically 3 ways to get a new trial almost automatically. One is a Brady violation, the state not providing you with information that's exculpatory. And another one is ineffective assistance of counsel, IAC. And another is new evidence that's come to light. A lot of times the same thing, the same action of your defense counsel or inaction of your defense counsel can be all 3 of those, can fit partially into a Brady violation, can fit into an IAC claim. Well, here we're going to see in a minute after one of you read these two issues. The first issue, he's framed the he's framed the issue around new evidence. And why that's important is it's a little bit easier standard to get a new trial. The system is rigged, set up, whatever you want to call it, such that the defendant has a lot of presumptions and safeguards in theory at the trial level. If you're a criminal defendant, the presumption of innocence, state's got to prove it beyond reasonable doubt, and on and on and on. But after, if you are convicted and you're on appeal or post-conviction, it flips. The burden is upon you. And we'll see that as we go through this. But so how you frame these questions, how you frame these issues, is this a new evidence issue? Is this an ineffective assistance of counsel issue? Is this a Brady violation? Is this prosecutorial misconduct? They all have different requirements, but the way he phrased this to me is why it's just so well written and it's brilliant. But so that's kind of the foreshadowing, the preview. Don't want to give away too much, but I did want to point out that this is one of the most important sections, even though it doesn't seem like it. Sheree, did you want to add anything to that about the importance of the issues and that sort of thing?
No, you put it very well, and I agree.
Okay, well, that's all I
Okay.
had to say on that, so we can start with that.
All right. So I will, I'll take the lead. I'll read this first page. Cherie, you can do the second page. So everybody who's in chat right now, hit that like button, hit subscribe, and just know, I have this enlarged. I won't be reading the chat for a while. So if you could, hold off on your questions, we'll kind of catch back up in a little bit. But we're going to start going through this document because it's a long one. And here we go. Statement of the issues. Number 1, whether state's witness Garrett Kurtz 2024 murder conviction for killing another person by ligature strangulation approximately 2 weeks before killing Nicole Bowen by ligature strangulation is newly discovered evidence that requires a new trial for Ashley Garth on her convictions for murder and conspiracy to commit murder. Number 2, whether Garth was denied the effective assistance of counsel at trial and on appeal. The statement of the case is as follows. On April 8, 2019, Ashley Garth was charged with assisting a criminal, a level 5 felony in case number, On December 18th, 2019, Garth was charged with count 1 murder, count 2 conspiracy to commit murder, a level 1 felony, and a count 3 assisting a criminal, a level 5 felony. On June 18th, 2020, Garth pled guilty to count 3 assisting a criminal, a level 5 felony. On October 2nd, 2020, the state filed a motion to withdraw the plea agreement. On October 21st, 2020, Garth's guilty plea was rejected and her not guilty plea was reinstated. On April 29th, 2021, Garth filed a motion for change of plea, hearing on a plea agreement on count 3, assisting a criminal, and count 4, involuntary manslaughter, level 5 felonies. The court heard evidence and rejected the proposed plea agreement. on May 17th through 2021. So this was her trial. Garth was tried by jury trial. So before we go on from there, let's just kind of give just a quick overview of what transpired here with all of these plea agreements. And I'll speak on my opinion on what transpired here. There were several plea agreements that were offered to Ashley, and there were several that she rejected. She wasn't willing to accept a plea. They were very much leading towards a manslaughter plea agreement, which ultimately she did not accept. She did accept assisting a criminal plea agreement simply because the assisting a criminal fell in the lines of her not coming forward immediately after the murder. She was willing to accept that. She went to court for a hearing on that. And then, unfortunately, at that hearing, the judge says, no, I'm not taking it. So everything was reinstated back to the original charges of the felony murder, conspiracy to commit murder, and assisting a criminal. And she took it to trial. And so, Travis, is that basically correct, or am I misquoting any of that?
No, and I'm glad you paused here. I actually highlighted some things. So this section we're in, statement of the case, is the procedural history. What happened leading up to trial, what happened in trial, what happened on the direct appeal, and how did we get where we're at? And I've got all of that highlighted in yellow, bright yellow, what you've just gone through on the bottom of page 6 there. And so, they kind of had a deal worked out for the assisting a criminal. That's what her co-defendants ended up pleading to. That which is Talitha Beckley and Jasmine. And what did Chris Mathis plead to?
I believe he pled to obstructing justice and then he was sentenced. He served his time. He got out, and then turned around and attempted to go back into, I believe, the Newton County Jail and attempted to pass drugs to an inmate. And so everything that he had prior to the obstruction of justice case was brought back forward. So that's pretty much what he's serving time for. Jasmine pled to assisting a criminal, and she is already out. Talitha Beckley had prior charges, and she had she had a converted case, so that was compiled onto the assisting criminal. So she's actually serving time. She's serving more time for her previous charges than she is for this one. And I believe I have it estimated based on her out date. She'll be out within the next 2 years.
Yeah, she got 8, right?
I believe so, yes.
So, and then, so it sounds like here that they're discussing, they renegotiated the deal right before the trial setting, and where she was going to enter a plea, assisting a criminal and involuntary manslaughter, but the court rejected it, which it has the right to do, and busted the plea deal, is what we call it. And that was May 3rd was that hearing, and then they started trial 2 weeks later on the 17th. And I don't know what they had worked out on that. But if the court won't accept the plea, then yeah, you've got no other choice. You got to go to trial. And but I think you described it perfectly. But those were significant things that occurred. Ashley's mother was there at that hearing and
Nicole,
stated to the
Nicole,
judge she was against the plea deal.
Nicole, that was Nicole's mom. Yes. What transpired there?
Yeah, Nicole, I'm sorry. Did I say
Uh,
Ashley's mom?
yeah, that's
Ah,
okay.
yeah.
That's
The
okay.
the the,
Um,
the victim's family opposed the plea deal. Yeah.
yeah, what it boiled down to was it was actually at this point in time it was down to just the assisting a criminal, and Ashley agreed to take that because she would have only had to have served a little bit more time based on the time that she had already served from the arrest, and she would have been out. But what happened is, Nicole's family came forward. They gave impact statements, and Nicole's son spoke. And the judge basically told the courtroom that he lost his mother at a young age, and he wasn't going to allow the plea deal to go through. So it went to trial, which started on May 17th, and it was a 4-day trial. So I'm going to continue to read on this page. It says Garth was tried by jury trial. The jury found Garth guilty of count 1 murder, count 2 conspiracy to commit murder, and a level 1 felony. I'm sorry, conspiracy to commit murder, which was a level 1 felony, and then count 3 assisting a criminal, a level 5 felony, and not guilty of count 4 involuntary manslaughter. The court sentenced Garth to concurrent terms of 48 years for the murder, 30 years of conspiracy to commit murder, and 3 years for assisting a criminal. On January 31st, 2022, the Court of Appeals affirmed Garth's convictions. The Supreme Court denied the transfer, Garth versus State. On February 22, 2022, Garth filed her pro se petition, which means on her own behalf, for post-conviction relief. On March 22, 2022, the state filed its answer on the PCR, which is the post-conviction relief. On August 29th, 2024, Garth filed an amendment to petition for post-conviction relief. On November 7th, 2024, the court held an evidentiary hearing on the amended petition. The parties submitted proposed findings of fact and conclusions of law. On November 22nd, 2024, the court denied the amended petition and its findings of fact and conclusion of law. Garth filed a notice of appeal on December 16th, 2024. The clerk filed notice of completion of clerk's record on December 17th, 2024, and notice of completion of transcript after two court reporter extensions of time on February 28th, 2025. That's a lot of dates. That's a lot of things to remember. The most important fact is so far on each level of her petition for relief, in her post-conviction relief, she was denied. And once, every single time a motion is filed, a new deadline is created. So it gets pushed and pushed and pushed. And in Ashley's case, she had a 1-day hearing in November, on November 7th of 2024, that Cherie and I attended. It was a 3-hour long hearing. They're then given a 10-day turnaround for both sides, defense and state, to file their briefs, which they did. Once the judge rules, then the court reporter has to basically submit the entire transcript of the hearing. In this case, it was a 3-hour hearing, and the court reporter needed 2 extensions to get the 3-hour hearing transcribed and submitted to the court. And that's pushed it back now an additional 2 months for this to move forward. So I think we can skip on to the next part. Cherie, if you want to read the statement of facts, unless Travis or Cherie, you have something to add to that.
I've got one quick thing. So it's in here about the amended petition on page 7. It talks about she filed in February 2/22/22. Really? That's when she filed her pro se petition, 2/22/22, February 22nd of 2022. The state filed an answer. Then on August 29th, Garth filed an amendment to petition for post-conviction relief. So that's a huge gap. Talk about a delay. That's 2 years, 6 months. Right?
That's the backlog in Indiana with
Right.
public defenders right now. That's how overloaded they are.
Right.
She had to wait for.
So yeah, this actually isn't a public defender. It's the Indiana public. What do they call it there? All this defender office does is post conviction. It's the public defender of Indiana.
Mhm.
All they do is post conviction and death penalty appeals. And most states, like Sheree and I are used to, Wisconsin, you don't get a post conviction attorney. You either got to get somebody, get your family to hire one, or Innocence Project to come in. And without that, you file your own, like Stephen Avery did. What he filed, he got from the law library, probably at the prison he was at in Wisconsin. And it was worthless. It's not one valid legal argument in that brief. And then, if he got an attorney to come in and substitute in, and that's kind of what really saved him. There's problems with that we don't need to go into right now, but in Indiana, their system is if you can't afford a post-conviction attorney, they have the forms in the law library, and she filed her pro se petition. But yeah, there's a huge backlog, and so she had to wait until the Indiana Public Defender's Office reached her case. And then the amended petition is the one that the attorney filed on her behalf, stated the correct issues, stated things in a proper way, that she wasn't waiving anything in her pro se petition. But that's a very unique difference. And Cherie practices East Coast. Does your home, Texas does not provide you with a post-conviction attorney either. Does your home jurisdiction give you a post-conviction attorney for free if you can't afford one where you're at,
No,
Cherie?
I'm in New York, and no, not as far as I know. I'm pretty sure that we don't. I don't. Not very many states do they? Or aren't you sure?
Yeah, I was really surprised. I wasn't even aware that they did that. But yeah, so there's good and bad on it. The good part is you get one, and that's all they do in that office. They don't. It's not like a lot of public defender offices where you got lawyers that are handling misdemeanors and traffic offenses, and then defending major felonies and murder and death penalty cases, and then you have an appellate section. All this office does is appellate work and post-conviction work. Um, and so, in talking to Michael Osbrook about that office, he's highly complimentary of the woman who runs it. Her name's at the bottom of this thing. Oh, well, if it wasn't 43 pages, I got to scroll to the bottom.
Isn't there
Amy
Amy? Yeah, it's Amy.
Carrazas,
Yeah.
who is tied tangentially to the Richard Allen case. And then he also spoke very highly with John Pinnow, the particular attorney in that office. And so that's good. The cons, the downside is that, you know, they have limited resources, and you just have to wait until your turn comes up, and 2.5 years.
Yeah,
But
that's
Cherie will tell you that's a lot better than getting impatient in another jurisdiction like Wisconsin, filing your own petition, and having the court rule on it, not knowing how to respond and do different things. You've blown your post-conviction chances because you're procedurally barred.
hard, right?
You are screwed. Here, you might have to wait 2.5 years to get your attorney, but once you got the lawyer, boom, set it for a evidentiary hearing. You know, we've seen in other jurisdictions, it's just been an impossibility to get an evidentiary hearing. But yeah, so I thought we should bring that out, and we have, but
Well,
lot different. Yep.
at Ashley's hearing, and I don't know what significance it holds in the office that John Pinnow works out of for the post-conviction relief attorneys that work for the state. But he made it very clear at the when we met him, when me and Cherie met him, that I'm assuming that he's got some seniority in the office, but he made it very clear to us that he only takes cases that he sees a positive outcome. And that's why he took this case. That's why he specifically picked up this case. And I don't know how that works, but the fact that, you know, he said that made me, I was kind of very pleased to hear that. Like, good, you see the light at the end of the tunnel. It's going to be a long road. We know that, but he did say that to us right before the hearing started. So that was a good feeling.
Yeah, that's good to hear. Cherie, what was your take on that?
Well, that's the way I understood it too. And before we went to the hearing, I had looked up some of his cases, and I did see that a few of them that where, you know, he would sign on as the attorney kind of, but then he would later on submit something saying that, you know, he didn't see anything that's really something that he could grab onto and, you know, represent him on.
Yeah, a lot of public defender offices, more traditional ones that have an appellate division and are doing direct appeals. In Texas, it's called a Anders brief. I'm not sure if that's a Texas case or a U.S. Supreme Court case, they call that. But in any event, there are a lot of appeals where there's just no good faith issue. And that's actually part of the system in Indiana. And it was probably a trade-off with the legislature saying, yeah, we'll come up with the funds for this office and we will provide indigent defense on post-conviction relief, but we want a screening process. We want that the Indiana public defender assigns a lawyer. They meet with the person convicted. They go over with the person what they think the issues are. They investigate it. And then if they don't see anything valid, they notify the defendant that they're getting off the case and they need to carry forward. Well, so that didn't happen, meaning her attorney thought that there was something meritorious here. And then, you know, and so I'm not sure if he was talking about that process, but, or if he's got enough seniority that he can select cases that have a decent chance of the court expanding an area of law, expanding a doctrine. And you can actually kind of see this later on in the brief. He's asking for a little extension of what's already been decided before. And so I'm glad you all mentioned that because that makes a lot of sense here. So on this statement of facts, I think Cherie's going to read that whenever you all are ready. You may just want to pause, Amy or Cherie, whenever you see something significant, or we can kind of see if there's any questions as we go along, or however you want to do it. We can kind of go page by page and see if there's anything, anybody has any comments. But I have a lot of notes about stuff in this section, but we can do however you want.
Okay, Cherie?
Yes.
If you want to take on the statement of facts, and for everyone listening, I appreciate you guys. Everybody's slowed down in the chat. Everybody's just listening. We have a good amount of people here, so we appreciate you being here. But statements of facts are going to discuss the actual facts of the case, what we know, what happened, the injuries to Nicole, and we'll go through it. And then anything that we feel we need to touch on, we'll touch on. The good stuff is going to be in the later half of the brief where we get into the arguments that John Pinot presents on Ashley's behalf. So for here, we're going to go through it and we'll touch base on what we need to. Go ahead, Cherie.
Okay. On March 30th, 2019, Nicole Bowen's body was discovered in a semi-trailer 3.5 miles north of Kentland. Her body was wrapped inside a blanket, and different types of tape were used to secure the blanket around the body. There was tape around her ankles, and her arms were taped together at the wrists behind her back. A scarf and electrical cord were tied around her neck, with the cord leaving marks on her neck. There was a clear plastic bag over her head. Forensic pathologist.
Okay. That's as far as I could get. So what's with this clear plastic bag thing? Did y'all know about this, or did I just forget about it? I thought he said he got trash bags. were y'all aware that it was a clear plastic bag on her head, or do y'all agree with that testimony?
My my under my understanding was it was like a grocery bag, like a clear grocery bag that you would get like at the supermarket. And I remember him telling Detective Rowe that he got it from underneath Jasmine's kitchen sink.
Okay.
It
And
wasn't it was not a trash bag. It wasn't it wasn't like a kitchen trash bag. It was some sort of a grocery bag. But I do remember him saying that he got it from underneath the kitchen sink.
So they're citing, um, and I apologize to anybody out there that family, friends of Nicole's, or anybody victim of a violent crime like this. Been doing this as long as I have. You tend to talk about this stuff in a clinical, um, surgical manner. Meaning no disrespect to anybody by doing that. It's just one of the hazards of defending people. But so they say. Tape, all of that's important later on. I actually even put it in orange. There was a clear plastic bag over that portion of the anatomy. And then they are citing, I believe that's the trial transcript, volume 2, page 172. And then they're also um, citing an exhibit volume, page 30, which I'm assuming that's going to be, nope, it's not. I don't know what they're referring to there, what that exhibit would be. Maybe that's a photograph.
What's the
Um,
exhibit number?
it's just exhibit volume, the volume of exhibits, page 30. And unless you have that, um,
Um, I'm looking right now. I do have all the exhibit. I do. There's 135 exhibits in this case, and I have them
yeah, but
all.
that won't help you because what they do is they put all of those exhibits and bind them together and paginate them. And they're referred to as the exhibit volume. And we don't know how they did the various exhibits. We need to index to that volume. Um,
I have an index. Hold on one
okay.
second. I'm pulling up. I do have the index. Let me see here. Um, let me see.
So there's going to be two indexes. There's going to be a clerk's index, which is designated as DA. I don't know what those letters stand for, but I can tell that the clerk's record, it's like DA 120. Again, those are page numbers, but all of the pleadings are referred to by DA. And then, so this is going to be the trial, the direct appeal. There was an exhibit volume um, that was submitted to the appellate court. And if you have the index to that,
That's the one. I do not have the one for the appellate court. I have the one from the trial, not the one for the appellate court.
okay. Um,
But there's,
well, so I mean, it's done at the trial court, and they send it to the appellate. What does the what page number lines up with the exhibit for that index?
I'm gonna pull it up. I'm trying to pull it up.
So page 30.
Okay, it's loading.
But we can go on. I'll just make a note that we want at some point, not tonight, but later on, we want to see whose testimony that was at trial, volume 2, page 172. And then we want to take a look at that exhibit. If it's a photograph, in all likelihood, we may not have it. I don't know. We might. But clear. That's the first time I remember hearing clear plastic bag because
Okay, here we go. Let's see. Why are these skipping? There doesn't appear to be a 30.
it's not exhibit 30, it's page 30. So unless that thing is an index that says exhibit 8, for example, is page 22 and exhibit 9 is page 23, unless it's doing that, we don't have what we need.
Okay, let me pull this off because we get into autopsy photos and all of that. Let me see if I can find the actual page 30. In the meantime, Cherie, if you want to go ahead and continue to read.
Okay.
Do either of you remember prior anything about a clear plastic bag? Reading about that before the evidentiary hearing, or do you remember that being discussed or asked of anybody at the evidentiary hearing?
I remember the bag over her head being discussed by Garrett. When you go through, let me see here.
Okay, that's all I needed to know is where that came from, and I'll be able to figure out if that's
There was, yeah. I'm looking at the pictures. It appears they're talking about. I wouldn't say it's a clear plastic bag. It's more of a frosty white bag that was tied over her head. Because
okay.
I think that's what I'm trying to look at it behind the scenes, and it's a very
Yeah,
small photograph.
it's not that significant. It's just I'd never heard clear, and it could be um, a super minor error on John Penau's part because he clearly has clear plastic, but
Hmm.
sometimes these things, it's just an example of, um, the other side, if this was more of a relevant issue, um, the other side is going to pound on that. And
Hmm.
Cherie's used to seeing that in the Avery case. The state, in one of the briefs, came back and said the appellate counsel was, once again, you're misstating the record, and just it got really, really bad. Just how sloppy the brief was, one of them, on just stating this stuff that wasn't supported. So for people that aren't used to looking at this stuff, so this one sentence says, there was a clear plastic bag over her head, and then the citation, TR, which is trial transcript, volume 2. They're put in, they're bound into soft cover volumes, and so volume 2, and then 172 is the page where somebody is giving the testimony at the trial, saying, describing the bag, and then also is referring to an exhibit volume, which there's just one, and it's page 30 of that exhibit book. And the whole point of me bringing this up is just that, the other side is going to be scrutinizing the citations. Neither side is going to accept what the other side says. And if there's a statement in these facts that Cherie is going to take us through that is misrepresented, made up, and it could be a simple, honest mistake, but if it's important enough in the response, it's going to be brought up. And that's really all I was bringing this up for, is just an example. But Cherie, did you want to add anything to that? I mean, you've got experience with this, that this stuff can sometimes read really, really good, because they're really good at setting out the facts, but they don't always jive. Did you want to add anything to that?
No, I agree with you in it. Yeah, they will, the other side will pick over anything they can, and to find fault with. That's what I found.
Well, Michael Osbrook is in the chat, and he states that John Pinto almost certainly took that straight out of the testimony in the trial record. John doesn't make those kinds of mistakes, he says.
Yeah, that's what Michael told me months ago about John. So I'm not saying that at all. Really, Michael's the one we should have in here. He's forgotten more about how this stuff works in Indiana than I will ever know. But so I just wanted to bring up an example of that, and then Cherie, if you're ready, we can keep going.
Okay. Forensic pathologist Thomas Sozio performed the autopsy and prepared a report. There was a ligature mark on the left side of the neck. Bleeding was present in the muscles on both sides of the neck, which is often seen with ligature strangulation. The cause of death was neck compression and ligature strangulation. A brown extension cord was wrapped tightly in a knot around the neck, and the scarf was tied tight around the neck. Garrett Kurtz became the primary suspect. Kurtz led the police on a short chase and was arrested in Bowen's 2005 Scion. Detective David Rowe questioned Kurtz. Kurtz initially claimed Chris Mathis had committed the crime.
I'm going to bump it. There you go.
Detective Rowe interviewed Ashley Garth on April 3rd and 4th, 2019. Garth stated Nicole was like an enemy, her boyfriend's other girl, and they got in a fight. Garth got hit in the left eye, and Kurtz broke up the fight so fast that Garth did not even get to hit her. Kurtz grabbed Nicole from behind, put her in a headlock, choked her out, and she fell to the floor. Garth denied grabbing Nicole, denied having her arm around her head, and denied having her in a chokehold. Kurtz yelled at her to help him. Garth thought Kurtz put a cord around her neck. She denied grabbing an extension cord and did not hand anything to Kurtz. Kurtz used duct tape, and Garth thought there was a bag over her head. Garth denied helping tape up her body and did not do something to help Kurtz. Garth accused Kurtz of previously choking and strangling her, tying her hands behind her back, tied her ankles, and had taped her across her mouth. He turned the music up so loud so that no one could hear her scream. The incident ended when Kurt's grandmother came to the door. Garth was wearing a white hat when first questioned by the police. Detective Rowe also interviewed Talitha Beckley and Mathis. Forensic biologist Brian Good testified at the trial about the DNA evidence, and his report was admitted. There was strong support Garth's DNA was on the fingernail scrapings taken from Bowen. There was no DNA evidence on the extension cord used in the ligature strangulation. There was strong support Kurt's DNA was on Bowen's scarf, while there was limited support Garth's DNA was on the scarf. Kurt's DNA and not Garth's DNA was on a partial roll of duct tape. There was strong support that Garth's DNA was on a cardboard tube found with her body. Kurtz pled guilty to Bowen's murder and was sentenced to 55 years. He testified as a state's witness at Garth's trial. He stated he was not getting anything to testify and had nothing to gain or lose. He was testifying because the mother of his two boys was taken from them. That was wrong. He was part of it and wanted to make it right. Garth was also part of it. Kurtz said that. Kurtz testified he had conversations with Jason Palladino and Garth about getting rid of Bowen, and it had been planned for 2 months. He's talked with Palladino that it had to be done, but Garth was not part of that discussion. Garth told Sergeant Michael Collins she overheard Kurtz say to friends he was going to kill Bowen. Would you like to read some more now, Amy?
Yes, I can.
Okay.
So this is page 11 of 43.
Okay.
Kurtz testified Garth and Bowen exchanged words and then got into a fistfight. He, Kurtz, wrapped Bowen in a chokehold from behind, and she collapsed. He yelled at Garth to hand him an extension cord, and she did. He tied it and he placed it around Bowen's neck, handed it to Garth, and she pulled on it so tight the extension cord broke. He picked up the couch, and Garth grabbed an extension cord. Makes me so angry. Garth grabbed an extension cord, grabbed an extension cord under the couch. He tied the scarf around Bowen's neck. Kurtz grabbed 2 trash bags and a roll of tape and taped Bowen up in a bag. Kurtz carried her to the car, and Kurtz and Chris Mathis disposed of the body. The next morning, he, Talitha Beckley, and Garth got into Bowen's car and drove away. State's Exhibit 50 showed Bowen, while alive, wearing a white hat. Kurtz thought the photograph was taken the day this transpired, and that was the hat Bowen was wearing when she was with Kurtz. He wanted to say Garth took Bowen's hat, and he had seen Garth wearing it.
We have someone backstage.
Okay, hang on. Hey, Michael Osbrook. He's muted.
Hey, Michael, can you hear us? You're muted.
What did he just say? Yeah. I don't think he realizes he's muted. Okay, I'm gonna keep reading. He'll pop in. Here. I do have preloaded these pictures of these hats, and reading this just is infuriating me. So, States Exhibit 50 shows Bowen, while alive, wearing a white hat. Kurtz thought the photograph, he didn't say he thought, he testified that the photograph was taken the day that Nicole died. It was taken the day this transpired, and that the hat Bowen was wearing when she was with Kurtz. He wanted to say Garth took Bowen's hat and he had seen Garth wearing it. Defense counsel cross-examined Kurtz about being charged with strangulation and invasion of privacy, where Garth was the alleged victim. Those charges were dismissed after Kurtz pled guilty to murder. He refused, meaning Kurtz, he refused to talk about the January 2019 incident with Garth. Counsel questioned Kurtz about a letter he wrote to Garth, and Kurtz admitted he wrote the letter. Did we just lose Travis?
Yeah, he just fell out.
There was an objection to the admission of the letter. So there was a letter that Garrett Kurtz wrote to Ashley while they were both arrested on this case, where he's telling her to shut her mouth. I've read it. I'll read it again down the road, but he wrote her a letter and told her to shut her mouth. The court sustained the state's objection, but ruled defense counsel could question Kurtz about the letter. Counsel cross-examined Kurtz about his statement in the letter. I killed Nicole because I was protecting you. Kurtz responded, we both killed Nicole. Ashley and I both killed Nicole. Counsel asked Kurtz if he recalled blaming the murder on anyone else. He responded no, and said he did not recall telling Detective Rowe on April 1st, this is the interview that we just went over last night, where he spent 3 hours describing how Chris Mathis killed Nicole. Sorry for ad-libbing, but I have to put that in there. He responded no and said he did not recall telling Detective Rowe on April 1st, 2019, that Christopher Mathis killed Nicole because he was higher than a kite. Counsel was unable to impeach Kurtz on cross-examination with his video statement. Well, Kurtz's video statement was not played in court, nor was it transcribed, and nor was he questioned about the video statement in trial. Detective Rowe later testified Kurtz initially told him Mathis had committed the crime.
Travis is backstage.
Okay, let me pull him in. Okay. Welcome back, Travis.
Hey. Michael, can you hear us?
I can absolutely hear you.
Wait, we can hear you. So you have any comments up to this point?
No, I think the only comment I wanted to make, I really, other people are kind of like Delphi, much more up on the facts than I am. I think I just wanted to say that, this brief is really good. You've got to give the Court of Appeals a way that you win, and you're not going to win on the facts, but the beauty of John's brief is that he points out it's de novo review for the conclusions of law, and he points out that the post-conviction trial court conclusions of law don't fit with the findings of fact, And that gives some reason for hope for a win on appeal. Not a certain thing by any means, but if you don't give the court a way for you to win, you can't win. And it's given them a pretty good way for him to win, or Ashley.
Yeah,
I
do
really don't have
you?
much more to say about that.
Well, Sheree and I had a question. We were kind of talking about this before we went on. So they're in Indiana, and some judges in Texas will do this too. They'll hear the testimony in the evidentiary hearing, and then they'll tell both sides to submit proposed findings of fact and conclusions of law. Both sides submit it. Judge goes through and picks picks what he likes from or she likes from each proposed findings of fact and conclusion of law, puts together their order. They can add other findings of fact that neither side presented. They can add their own conclusions of law. And then, as you alluded to, on appeal, very hard to disturb the judge's factual findings. It's a clearly erroneous standard, I believe, in Indiana. But the conclusions of law, which here, what the important one is that this information, this new information, if a jury had heard it, would probably have changed the outcome of the trial. So, in looking, what is was
Get to
kind
the
of
question. Get to the question,
so the
Travis.
question is, I haven't seen where they, a brief where they go through and say, yeah, the judge said we got 8 out of 9. Where they messed up is the ninth one. So, how does that work? And what is what's the appeals court going to be looking at on de novo review for a conclusion of law?
Well, I mean, the first thing they're going to look at is whether the newly discovered evidence fits number 9 or not. If the judge got that wrong, that's a question of law. And the other thing is there's the hypothetical about probably would have produced a different result. And Scalia wrote a concurrence in Benitez something or other versus United States, where he talked about all these standards of review, that hypothetical things that judges have to go through that are, I think he says that they're more akin to divining than judging. And it's true. I mean, it's actually doing the hypothetical is in a way the ultimate act of judging.
And are
Same
you?
goes with, yeah, go ahead.
I'm saying, you're saying like so number 9, like the hypothetical of a different outcome, which would have been if in Ashley's original trial there would have been that nexus of Garrett
Please don't use
being
that word.
yeah, that's the word. If there was a connection to the fact that Garrett, like there's two main factors in this case that I feel completely were left out of the overall picture in Ashley's trial, and that number one was it was never put in the forefront that Garrett and Nicole were actually a couple. It was never put in the forefront that the two of them had been posting on Facebook that they were engaged. And then there's the fact that there was this whole other similar murder, and that murder fell in between the initial attack on Ashley with ligature strangulation, duct taping, hog tying, the abuse that happened in January. Then the next victim actually was his life was exhausted based on those same similar means. And then 16 days later, you have Nicole. And the trial court, Ashley's trial, the jury never heard any of that. I mean, Ray's case wasn't even charged as a murder until well after Ashley's trial.
So
So,
let me interrupt you a second. Let me interrupt you. So there are two things about the other murder, Hamish or whatever his name was. And one is, had Kurtz been convicted already, just the conviction could have been used to impeach him. But then there's the other question of whether the facts of that murder sort of fit other acts evidence, that is to say, Indiana Evidence Rule 404B. In other words, do the facts sort of add up to an MO? And maybe they do, maybe they don't. I don't really have an opinion on that. I will
well,
say that this really comes down to a pretty simple question. And that is, if the Court of Appeals is going to think that had they known about Kurtz's conviction for the other murder, leaving aside, let's just leave out for a minute whether it was similar or not. Maybe that evidence comes in, maybe it doesn't. Just the murder conviction. Is it more likely than not that there would have been a different result? And a different result doesn't. It's an interesting question for Strickland prejudice or ineffective assistance. The slightly lower standard is a reasonable probability of a different result, less than 50%. For newly discovered evidence in Indiana, more than 50%. But the reason I raised the effective assistance issue is federal law on the subject is we're talking about a different result. All you have to do is, would it have persuaded one juror to acquit? And I can't tell you what the answer is on newly discovered evidence question as a matter of state law.
Well, how much weight do you think, if you raise that issue about the prior bad act, and then you add to that the fact that the victim in this case, who was allegedly in this case, her life was taken because she was a snitch, that she was involved or was present during the prior homicide. And
Yeah,
that,
I mean that's another motive killer for sure. And I don't know that exonerates Ashley. I mean, the question. Look, I mean, isn't really there a pretty simple question here? And you can say no, it's more complicated. Did Kurtz do it alone, or did Ashley help him?
no, right. I mean, no, he did it alone. I mean, there's all of the evidence
Yeah,
points
that's
to him.
that's the big
His,
that's the big question.
yeah,
And
all,
and so Ashley says he did it alone. Um, Garrett testified, no, she handed me a cord, and the you know
and then,
jury.
and not only did he say, and that's the other issue is when you look at the trial, neither one of his interrogation videos were played. And it went from she handed him a cord to he backtracked on that in the
So
interrogation
what
video.
Michael's trying to tell you, Amy, is that thank God John came up with this issue
Hmm.
about if the jury had heard about that or if he had been convicted on the older case,
Mm-hmm.
Ray Hanish was before Nicole Bowen by 16 days or whatever. If
Right.
the jury had known that, so he came up with this great argument, because you're not going to win post-conviction about, you go in and say, well, this doesn't make as much sense as all of this other stuff that you put
Right.
in a hearing. You're never going to win. You're done. You're toast. But he came up with this brilliant argument that this is new evidence. And, you know, I think there's more to it, that it's very, very difficult to prove. But, you know, I, I, I just, part of me just says there's got to be collusion between the two prosecutors' offices about, okay, well, which one should go first? And, well, you know, we can convict um, 4 meth heads, people we've suspected are involved in other stuff, plus get Garrett on the murder if we do ours. Um, you know, Garrett Garrett won't be a witness for us in our murder case if he knows he can be questioned about his involvement in the Ray Hanish case. So that ruling was pivotal, that the defense could not question him about his involvement or lack of involvement in the Ray Hanish murder. Um, and it's just absolutely devastating. And the beautiful part about the brief is they point out all of the things that could have been brought in if things had proceeded, you know, in the normal course. But
Yeah, in
you
some ways
know,
the evidence rules are dumb, but the other thing, and I forget whether John mentions it or not, just the murder conviction alone would be impeachment. I mean, besides the situation, the factual situation, just the fact. I mean, there is an evidence rule. I forget which one, but you can use a murder conviction to impeach somebody.
yeah, he does bring that up.
Yeah, and so it's really would the jury have believed? That is to say, now would the Court of Appeals sufficiently believe? Um, there's a better than 50% chance that either Ashley would have been acquitted or a juror would have voted to acquit, and should she get a new trial to be able to use it. And I got to say, one of the big things Travis talks about collusion between the prosecutors. Yeah, I mean, I think there's almost certain plus a strategic decision made. And if I'm sitting on the Court of Appeals, I say, this guy was convicted of this other murder. It was just a question of timing. And boy, is this a close case. And yeah, she ought to have another shot at. She ought to have another shot where the evidence of the murder comes in, and let the trial court figure out whether what Kurtz did earlier was sufficiently similar to make it MO evidence.
Right.
Yeah, that's the big
I mean,
question I had. Is you just covered it, that what's the Court of Appeals in Indiana going to think about the injustices that were created as a result of, whether real or imagined, strategic moves between a co-defendant who has crimes in different counties, and the prosecutors in each county can use strategy. Will you hold off on yours, and let me make a deal with him, and he'll testify against Ashley, and I'll get Ashley, and then you're free to go on your case after that. I'm glad to hear Michael thinks that the Indiana Court of Appeals may not be too impressed with the way this went down. Texas, they wouldn't.
Yeah, I have no idea. I mean, Court of Appeals. I mean, there's a very low percentage rate of reversals in post-conviction cases. I mean, I think it's middle single digits. But this has a shot. The Court of Appeals, the Indiana Court of Appeals, is a very tough court, and it's also, the Indiana Supreme Court on transfer. If the Court of Appeals does the wrong thing, the Indiana Supreme Court might step in, because there are a couple of legal questions here, and the Supreme Court might want to say this isn't playing pool fairly. Hold off on a charging decision and a conviction so that your main witness and your only witness really against Ashley can't be impeached.
And Nick McClellan gave him a hand too by dropping the charges of strangulation that first he tried to he did strangle Ashley. He didn't kill her, obviously, but he came near it. And that got dropped, a week before he pled or something like that to this?
Well, and it might have been a global deal, and who knows? I really came on just to give you all my take on the sort of legal setup of all this, and I think Ashley's got a good shot. Whether it depends on the judges and the Court of Appeals, and I don't.
Well, thank you very much, Michael. But one thing, I thought the brief could have used some more footnotes, but other than that.
You guys are funny.
But the hilarious thing about Travis and the whole footnote thing is that I actually I don't think footnotes on paper are a terrible thing, but footnotes in PDFs, which is what just about everything's filed on in these days, I think footnotes, if you can avoid them, should be avoided. They basically make reading footnotes in PDFs is just idiot.
Really wasn't the format. It could have been in the body of the brief or the footnote note. It was the content of that footnote, and I've never seen a trial judge warned what exactly was going to happen if things didn't go a particular way. I just had never, ever seen that. And I've read a lot of legal briefs at all levels, all courts. And I mean, I'm going to have mine framed and then get Michael to sign mine when I see him in person. I mean, it's just incredibly good. But we got a Sir Walter Scott, one of my favorite authors, quote, and we got a reference to a Hitchcock movie. So well done on John's part. Done a great job with
Pinot dating himself. John Pinot dating himself.
Yeah, that's for sure, unless you're just a Hitchcock fan. But yeah, that was really brilliant. But anybody got anything else? We can keep going with the facts. Or Michael, do you have anything else you wanted to highlight?
No, I'm going to get off, and I'll let you all keep going with facts. I also want to say that John Pinot's been around a long time. He's done really good work, and before he went to the state PD's office, he was in private practice for a long time, and he did a whole bunch of habeas cases too. So he knows what he's doing.
Yeah, I don't know if you were on yet, but earlier I had mentioned that I had talked to you about him many months ago, and that you were very complimentary of him. And yeah, this is all panning out. It's all fitting together.
And I guess, I'll make one last point, and that's something I said to Amy, and that is, and I could fit it in with the Pinot thing. There were a number of cases that John Pinot did that I certainly looked at, take to federal court, but the Court of Appeals just didn't give me an opening in federal court, and I couldn't do them, and I regretted not being able to do it, but I just didn't think, because of the way the Court of Appeals had decided the cases involved, that I could succeed. And so if everybody's thinking about, habeas is the next step or something, well, depending on what the Court of Appeals says, but newly discovered evidence also is not. The ineffective assistance claims are viable in fed court, but the newly discovered evidence part of it isn't.
Mm-hmm.
Well, I'm really glad you brought that up, because I wasn't aware of what the standard was on newly discovered evidence. And you're saying, which I have no doubt is absolutely correct, that the standard for materiality with Brady is a little bit less than new evidence in Indiana. And I actually reversed that, speculated why he couched the issue the way he did. And so he's couched it that way because that's the best fit and the most logical way to do it.
Brady or ineffective assistance?
Well, it's the new evidence part of it about that the fact that Garrett Kurtz pled to a murder afterwards constitutes new evidence. He could have made an alternative argument that maybe it was Brady to an extent, that, but I don't know exactly. He mentions in the brief that the trial counsel was aware that Kurtz was a suspect in that other murder. So, I don't know. I was just throwing out examples of what the common issues are on a post-conviction brief, and that there's a lot of overlap and there's a lot of strategy into which one you want to pigeonhole something as. But I'm glad you mentioned what the standard is in Indiana. It's actually a little bit higher for new evidence versus ineffective assistance of counsel. But
It's the same in federal court for newly discovered evidence, and it's the same in most states.
okay, anybody have anything else? And let Michael go before he's got to take off. Is there any questions for Michael in chat?
If she should win on the appellate level, the state can the state appeal that to the Supreme Court, that win?
Yep.
Okay.
And they will.
Well, I don't. It's probably not important, but isn't the Malter's son on the Supreme Court? Would that make a difference? Or he would probably recuse himself, hopefully.
No, he didn't.
Yeah, probably.
Well, he didn't recuse himself during Ashley's direct appeal. But now that we're aware, that's a whole different can of worms. But now that we're where we're at, Judge Moulter, I believe, should be retiring at any time. So if Ashley is granted a new trial, then it'll go before a new judge.
Yeah, which could be 100
You
times
know,
worse, or could be better. You just
Ju-
don't
Justice
know.
Moulter should be Justice Moulter should be recusing himself from any case his father's involved in. That's just silly.
Yeah, I mean, I agree, and it just comes down to the fact that not all criminals have a deep wallet and the ability to fight the system, and unfortunately, the system should work for everybody, but it doesn't always. But
Well, life works better for rich people than it does for poor people too. So
it does.
but I take your point.
Yeah, it sure does. And at this point, I just would like to see Ashley get a new trial, everything about the case come to the forefront, and the jury get to see. It's like with any case, just like with the Delphi case, put the facts, the real facts, the whole facts in front of the jury, and let's get a true outcome. I mean, Ashley's trial, I don't want to call it a sham. I don't think it was a sham. I think she had an attorney who had a good heart, just not the experience. And it was a complicated case. And even at the time that her trial took place, even Ashley herself didn't know all of the details of what had transpired before the night of Nicole's death. And everything like trickled in after I'm still to this day, after working on this case for 2.5 years, still uncovering things that I'm like, okay, that makes a whole lot more sense than what we had initially. So it's constantly evolving, but I do believe that if Ashley gets a new trial, she'll come home. I mean, the evidence is there to support that. It's getting there based on the four corners of a trial and the four corners of a document.
Here's hoping.
Yep.
Yeah, here's hoping.
So
Again,
anyway,
thank
thanks
you.
for the opportunity as always.
Thank you, Michael, for popping in. If you have anything else to say, you've got the link. You're always welcome.
Okay.
Thank
Thank you
you.
so much. Bye,
You're welcome.
Travis. Bye, Cherie.
Bye.
Bye, Michael. Thanks for popping in.
All right, Cherie, I will finish reading this page and then you can take the next one. We're only on page 13 and we got a lot more to go. So we got to boot, scoot, and boogie here. Talitha Beckley's deposition was admitted as Exhibit G when she was not timely at the courthouse. She saw Bowen slap Garth and Garth push Bowen when they were fighting in the living room. Garth came back into the bedroom and said Bowen had hit her. Well, I think that was meant to say Garrett had hit her. The following day,
You
Beckley
think what? I have a note about that. You think what?
It says Garth came back into the bedroom and said Bowen. Oh, Bowen. I'm thinking Beckley. Sorry. Garth came back into the bedroom and said Bowen had hit her. Well, Talitha had just stated that she witnessed it. And I think what actually transpired based on both interrogation videos between Garrett and Beckley was that Garth came back into the bedroom and said Garrett had hit her. When he broke up the fight, he hit Ashley to break up the fight and grab Nicole by her neck in like a full Nelson. And then Ashley kind of stood there for a minute, seeing that he wasn't going to let her go. He started yelling at her, and then she ran to the bedroom. But Beckley says Garth came back into the bedroom and said Bowen had hit her. The following day, Beckley, Kurtz, and Garth left in Bowen's car. The state offered Beckley's April 11th, 2019 statement, and it was admitted as Exhibit 56 when Beckley was unavailable, and it was a statement against her penal interest. Beckley heard Kurtz screaming and yelling at Garth. Garth responded by calling him names, and Kurtz smacked Garth. She heard Kurtz call Bowen a snitch and subsequently saw her hogtied on the floor, laying on her stomach. Jasmine Parker wanted to make her shut up and handed tape to Kurtz to put on her mouth. Kurtz had a rope around her neck, and it was tied to underneath the couch. Kurtz had Garth pick up the leg of a chair, and then it was that fast. What?
Okay, so what's that mean? I got a big note about that. Do you know what they're talking about here?
I mean, I'm guessing that these are all statements that were made by these specific parties. So the whole extension cord being tied on a leg of a couch, none of that was ever brought out until actually at trial. And it's hard to stay within the four corners of the document that we're reading because there's other things that we know. And if Nicole is hogtied with a extension cord around her neck and a scarf, and she's not moving or breathing, what is the significance? And how are we tying a extension cord under the leg of a couch if prior to that, Ashley had helped tie the extension cord around her neck and pulled on it so tight that it broke? I mean, you got to be a little bit level-headed here and say, okay, what makes sense, what doesn't make sense? And in here it says Kurtz had Garth pick up the leg of a chair, and then it was that fast. Well, we have the pictures of the inside of that living room, and there was no chair. There were two couches. And then right after the fact, it says Beckley did not see Garth physically assist Kurtz or hand him anything. She thought
she was really, really good for Ashley. Her initial statement when she came in and got interviewed by Detective Rowe, and then her deposition was really, really good, I thought. And then it switched significantly at trial.
And for me, I mean, speaking outside the box here, for me, what that boils down to is that I believe Beckley had knowledge about the murder of Ray Hainish, as well as Bowen. And because Garrett was willing to not put forth information about Beckley's involvement in the Bowen case, that was a scratch my back, scratch your back. I'm not going to throw you under the bus. In Nicole's case, if you keep your mouth shut about what I did to Ray Hainish, because at the time of Ashley's trial, Garrett still had not been charged. And he truly felt he was going to get away with it. And then after Ashley's trial, when the prosecutor went from Robert Guy to the new prosecutor who initially filed charges against Garrett, Talitha Beckley presented evidence against Garrett in that case. And she also was a witness in the Ray Hainish grand jury hearing. So there's a whole lot going on here behind the scenes. But at the end of the day, they really all try to like throw a dart at Ashley and then retract it immediately. And I don't know why, other than the fact that she didn't participate. Like where it says Beckley did not see Garth physically assist Kurtz or hand him anything. And then in the very next sentence, it says she thought Garth took a trash bag and tape to Kurtz. Well, before that, up here, she claimed that Jasmine Parker wanted Nicole to shut up and gave him a roll of tape. Like, all of this is like commingled and it doesn't make any sense.
Yeah, I think that's by design. Just he's putting all of it in there, and it's showing a lot of inconsistency. But it's clear why Talitha switched things around. This
The storyline changes constantly.
well, I need to see when she got charged with assisting a criminal, and then when she got appointed an attorney, and see if she had an attorney representing her during the deposition or how that worked. But if I'd come in at that point where she's given the deposition, I would have been, you 100% sure you remember her being hogtied on her stomach? Well, I could be misremembering that. And, well, you want to be super clear about that. And what extent you were high on meth when you were giving your initial statement to Rope, because the problem with the hogtied on her stomach is that gets into torture. She's alive. Everybody knows she's still alive, and they're allowing Garrett to finish her off at best, or at worst, they helped Kurtz finish her off. But that's why that changed, and I was really surprised when I was reading through that on her stomach, hogtied, and I'm like, holy cow! These people are freaking idiots. But we can let's go through the facts and finish that. But you know, Garrett's just a big idiot. He throws everything out. I mean, he's just a total idiot. But we can go through that in a little bit. But it's really good the way this brief's laid out, because even though it doesn't say it directly, he's got lots of room to come back in a reply to the state's brief, to point out all of this stuff. So, but however you want to do it, whatever order, if you want to pick
Well,
back up where you left off, or
yeah, I have one more. There's one more sentence on this page. I'll read it. It says Kurtz took Bowen's body out the back door and put her in a car. He later came back with Chris. Kurtz subsequently tried to sign the title to Bowen's car over to someone that they wanted nothing to do with it. Cherie, you want to pick up from there?
Okay. Beckley belatedly showed up at the courthouse and testified. She saw Garth and Bowen slapping each other. Garth and Kurtz came into the bedroom, and Garth accused Kurtz of hitting her, and Kurtz denied it. Beckley did not see Garth or Kurtz do anything and did not see Bowen after her fight with Garth. She did not recall Kurtz asking for tape and did not recall seeing Bowen laying on the floor with rope tied around her neck. Beckley testified Bowen was not wearing a hat and had scabs on her face. The prosecutor began his closing argument. Killers keep trophies. Is it the spoils of war? Is it the thrill of the hunt? Or was it just a sign of victory? Do we know? Was the defendant's trophy Garrett Kurtz, or was it the hat? The prosecutor argued in rebuttal closing argument. Garth, even wore Nicole's hat to the police station. Defense counsel argued on appeal, Kurtz's letter was admissible as a recorded recollection and on Kurtz's then existing state of mind. The state noted a copy of the letter was not included in the record on appeal. The Court of Appeals stated the subject matter of the letter and not the letter itself is the relevant focus for the purposes of evidence rule 803.5. Slip opinion at page 7. It concluded the trial court did not abuse its discretion in excluding Kurtz's letter. Garth presented evidence on her claims of newly discovered evidence and ineffective assistance of counsel at the post-conviction hearing. Excuse me. Charles Ray Hainish was last seen alive on March 13, 2019, and his body was found at his Reynolds residence on March 17, 2019. There were ligatures around his hands and wrists, feet, and neck, and the cause of death was asphyxiation due to ligature strangulation. Hainish was 5'8" and 170 pounds. Indiana State Police Detective A.J. Smith and White County Sheriff's Detective Eric Janke were assigned to investigate Hainish's death. The license plate of Hainish's car was run on March 14, 2019, based on a traffic stop in Lafayette. Garrett Kurtz, Kyle Stout, and Nicole Bowen were the three occupants of Hainish's car. Kurtz was initially charged with driving while suspended, while Bowen was arrested for possession of methamphetamine. Kurtz, Stout, and Bowen became suspects or persons of interest the detectives wanted to talk to about Hainish's death. Stout stated Kurtz and Bowen discussed going to Lafayette, and Stout went with them in Hainish's vehicle until they were stopped by local law enforcement. He had no information on Hainish's homicide. The detectives could not speak with Bowen because she had been killed in Newton County. They first questioned Kurtz at the Newton County Jail on April 4th, 2019, where he had been arrested in connection with Bowen's death. Kurtz initially stated Bowen's uncle owned the car and then claimed he was borrowing Hainish's car. He stated that he had sexual activity with Hainish but did not do the bondage and left. Kurtz accused Billy Isom of being present and possibly being involved in sexual activity and possibly bondage. Isom admitted being involved with Hainish and Kurtz individually but not together and denied involvement or knowledge. Isom did not become a suspect in the homicide. The last activity on Hainish's cell phone was on March 13th. There were a large number of text messages identified to Kurtz's cell phone. There were discussions about Kurtz coming to Hainish's residence and Hainish picking up Kurtz in the Carroll County area and bringing him back to the house. Hainish and Kurtz texted back and forth about sexual bondage and Kurtz's fantasy To tie people up, Kurtz referred to edge choking and having done it in the past. Edge choking was being choked to the edge of unconsciousness or autoerotic asphyxiation. Hainish appeared to be a willing participant to edge choking. Detectives Smith and Janke questioned Kurtz again on April 26 and confronted him with some of the evidence. Kurtz claimed Andy Alcorns was the one with the cell phone and was involved. Alcorns was charged in a different murder in Lafayette and did not become a suspect in Hainish's death. Kurtz changed his story and said he had bondage intercourse with Hainish. Hainish went limp and died, and Kurtz panicked and left. Kurtz took Hainish's TV when he left because Hainish had agreed to trade it for methamphetamine. Kurtz sold or traded the TV. The detectives did not have evidence Bowen was present when Hainish died or that she knew or was related to him. Detectives Smith and Janke brought the case to White County Prosecutor Robert Guy in June 2019 because they believed they had enough to charge Kurtz with murder. Charges were not then filed. Guy retired and Mark Delgado was elected as the new White County prosecutor. Delgado took the case to a grand jury and charged Kurtz in February 2023 with murder. Auto theft and theft. No one else was charged. The additional evidence against Kurtz included an admission to a jail officer he killed the dude because the dude molested me when I was a kid, and Kurtz did what he did to me. Kurtz had also written a letter to Talitha Beckley where he referred to his DNA being on the body in Reynolds. Kurtz's letter claimed a brother of his and a child had been molested, and they went and took care of it. They raped and strangled the subject and made it look like a sexual encounter. On January 25th, 2024, Kurtz pled guilty to Hainish's murder. The auto theft and theft charges were dismissed as part of the plea agreement. On February 20th, 2024, the court sentenced Kurtz as provided by the plea agreement to a 55-year term to run consecutive to his 55-year Newton County sentence for murdering Nicole Bowen. Kurtz's attorney noted that because of the substance abuse, Kurtz has developed over time what amounts to what I would characterize as a kind of Jekyll and Hyde personality. Lori James represented Garth at trial, and on appeal, she spent hundreds of hours preparing for trial and felt well prepared.
Sorry. Go ahead. I'm sorry.
That's okay. She was aware of Hainish's homicide in White County, had information Nicole Bowen was involved, and wanted to ask Kurtz about the White County case.
Do you want me to take over?
Sure.
Okay. Kurtz sent letters to Garth while they were in jail. James identified the petitioner's Exhibit 12 as a copy of Defense Exhibit E at trial, a letter from Kurtz to Garth. She established Kurtz wrote the letter. The state objected to the letter being admitted in part because the letter contained information about a murder in White County, and the case was then uncharged. The court ruled that the information was not relevant. The court had determined prior to trial it was not a charged case, and there was nothing trial counsel could do to get that evidence in. Trial counsel would have wanted to present evidence that Kurtz killed someone else by strangulation to show prior bad acts in history and to compare the circumstances in the instant case, as well as when Kurtz was accused of assaulting Garth, and Garth was saved when someone intervened. Counsel was aware of Kurtz driving Hainish's car and that Bowen was present. If Kurtz had been charged in White County with homicide and auto theft, counsel would have wanted to get into evidence who was with Kurtz in Hainish's car that would have produced a motive for why Kurtz killed Nicole Bowen. Kurtz did not, in his testimony, open the door to allow counsel to question him about the White County homicide. Trial counsel was able to read relevant portions of the statements Kurtz wrote in the letter and ask him about them. Counsel asked Kurtz about his statement, "I killed Nicole because I was protecting you." And Kurtz aggressively responded, "We both killed Nicole, and Ashley and I both killed Nicole." Kurtz testified at trial about Bowen's white hat. He had not mentioned in his pretrial statements that Garth ended up with that hat. That was a surprise. Garth told trial counsel she had owned that hat for years. The trial days went deep into the evening, and counsel did not have much of an opportunity to investigate anything. She did not have another witness to testify about Garth wearing a white hat. Garth's grandmother came to counsel after the evidence had closed and testified at sentencing about the white hat. Toby Garth, Garth's father, testified at the post-conviction hearing that Garth had a white crocheted hat she wore prior to March 28th and 29th. Garth was present for her 1-year-old niece's birthday party at Delphi Canal Park on March 10th, 2019, and was wearing a white hat. Toby Garth identified post-conviction Exhibit 13 as showing Garth wearing the white hat at the party. Toby Garth testified the white hat Garth was wearing when questioned by the police looked like the same white hat. He talked to trial counsel before the trial, but not about the white hat. He would have been willing to testify at trial about the white hat. Okay, so now we're on to summary of arguments. Do you want me to go on? Do you want me to keep reading?
If you're comfortable with it, whenever you need a break, I can take over. But I think you have a better reading voice than I do. So.
Oh no.
Loud and clear. I mean, it's nice and clear.
Okay. Well, we might not be able to. What time is it? We might not be able to get through this whole thing tonight. It's almost 10 o'clock. So we'll go through a couple more pages, and then we might have to resume this tomorrow or Wednesday. Oh,
You want to just kind of, since we're at the end of facts, you want to kind of go back and.
Yeah, we can do that, and we can end on that note, and then pick up where we're leaving off. That's great.
That'd be a nice break, yeah. Breaking point.
I'm trying to get us to where we are. Summary of. Okay, so we're going to end on summary of the arguments, and let's discuss what we just went over. I personally would like to reiterate that. So Robert Guy, the prosecutor in White County, who was overseeing Ray's case, I don't believe it was Robert Guy's decision, but when Ray's body was found on March 17th, for 6 months, the public and the family were made to believe that Ray Hainish, although he had been found tied to his bed with ligatures around his neck and blindfolded, they had alleged that he died by natural causes. And going into Nicole's case with Ashley's grandmother had hired Robert Delgado. He was a defense attorney at the time. She had retained him to represent Ashley in the Newton County trial for Nicole Bowen. And after receiving the retainer, a month or so after, Delgado did not come himself. He sent an associate to the prison, or to the jail, basically, and told Ashley that they had a conflict of interest, that they could not represent her. And that conflict of interest was that Delgado was going to be running for prosecutor in White County. And when Delgado became the prosecutor, he's the one who pursued the charges against Garrett in Ray's case. So that is a little twist on this story. But the fact that we do not know, and we will probably never know, if Nicole was present when Ray's life was taken. What we do know is that she was in the vehicle the day after and was arrested with Garrett in the vehicle. However, all we know is that Garrett continuously referred to Nicole as a snitch throughout the course of this situation. And we really don't know what he was accusing her of snitching on, whether it be the drugs, whether it be a murder, we don't know. So that's all we're left with. And the police were pursuing the both of them. And before they were able to get to Nicole, Garrett got to her first. Yeah, Garrett pleaded out on Ray's case, and there will never be a trial. So, Travis, Cherie. Where'd you guys go?
I was waiting to hear what Travis had to, he said he had a lot of notes, so
Mm-hmm.
I'm interested
He's
to hear.
muted. I don't know. Maybe, Travis, do you know that you're muted? There's so many details in this case, and you know, the thing about Ray's case is the fact that they have all these text messages prior to, and we've gone over Detective Janke's deposition, where Detective Janke describes to us they have Ray Hainish on video the morning of March 13th, twice at a gas station. He was there earlier in the morning. He went there a second time to purchase alcohol. Then he proceeded to go to Carroll County and pick up Garrett, which all of that communication was through text messaging. Then they go back to Ray's apartment. And then later on the 13th, all of a sudden you start to see the sexual sexting texts going back and forth about this edge killing. And the first thing that came to my mind was, why are they texting each other when they're under the same roof, if it's just them two? So then I thought, okay, well, did something go down and Ray has already lost his life, so Garrett is kind of freaking out and panicking and now going to try to play it like he's continuously done in every other situation he's been in, to make an excuse like, oh, it was an accident, we were involved, and he died accidentally. And so he picked up Ray's phone and starts creating this text thread between the two of them. That would be the only thing that made sense. Then I realized maybe that wasn't the only thing that was happening. Maybe the two of them were texting because someone else was there that they didn't want to know the conversation they were having. Who would have been that someone? So that's a whole nother can of worms. But ultimately, they have the last time that Ray was alive was March 13th. Garrett and Nicole were arrested the following day. 16 days after that, Nicole is dead. She died on the 28th. 5 days before that, ISP was at everybody's front door looking for the two of them. So, Travis. He might be doing something because he's muted. So that's where we're going to leave off tonight. What court and judge is handling Ashley's case? So Ashley's case was, she was charged in Newton County, which is where Jasmine Parker's trailer was, which is actually, it's Newton County, but it's considered Kitland. And it was held at the Newton County Courthouse. Judge Moulter was the judge. Jeff Durinsky was the prosecutor, and Lori James was Ashley's public defender. Lori James is currently representing a co-defendant of Jennifer Dean, and that trial's getting ready to begin in Carroll County. Just a little FYI, we talked about that the other night. But Judge Moulter sat on the bench. Ashley was found guilty. Her direct appeal went to the review board, and at the time, Judge Moulter's son sat on the review board. Judge Moulter's son now currently sits on the Indiana Supreme Court. So there's that. And Judge Moulter, the original judge who heard the case, is now getting ready to retire. In fact, I thought he was going to retire in January. I could be wrong.
I can't find it now, but it might have been on Facebook, but I saw where they were swearing in or whatever they do with the new judge. His name was Ryan, or else his last name is Ryan. I haven't been able to find it again, but I believe he's out and the new one is in.
Well, that's good. So if Ashley's case gets sent back and there's a hearing or she gets a new trial, it'll go before a new judge, which is great, which is what we want. So it is 10 o'clock. We've been on here for a while. We're going to leave it here on page. What page are we on?
21.
21. Okay. We'll leave it here on page 21, summary of arguments. We'll pick it up on another live. Yeah, I have to get to bed. Sorry, guys. Yeah, Mother of Dragons, me too. I have to be up at 3 a.m. for work. So we just had a lot of extra commentary tonight to add to all this. And we will get back to it next time. So good night, everybody. Have a good night. Thanks for being here. Ashley appreciates it. Her family appreciates it. See you the next time. Good night.
Bye.